We just left the courtroom and the judge received our motion to quash. It was set for hearing today at 8:30. All the parties were there, including the DOJ, which entered its appearance through two assistant state prosecutors. The private prosecutor, Mr. Keng, was also, private complainant rather, Mr. Keng was also represented by two law officers. And so we from the Free Legal Assistance Group entered our appearance for Maria, Ray, and Rappler Incorporated. What happened was the prosecution was given 15 days, a period of days, to file their comment in writing. We were given an equal period to reply. And thereafter, the motion to quash will be submitted for resolution. In the meantime, the arraignment will not be held. It will be held in abeyance until the motion to quash is resolved. Yun po nangyari. Sorry. Sino yun?
Did Justice Ascuna play any part? We saw him coming in.
Justice Ascuna?
Was it not him? Was that him?
Justice Ascuna, no. He was not there. I don't think he would be there.
Sir, William Keng is not present. He's just represented.
Wala, hindi naman siya nakita. Lawyer.
And sir, can you explain to us the motion to quash? You cited this very interesting. The PRO,
there's a lot of grounds there, but basically two specific grounds that the charge, the information does not state an offense. That cyber libel is not an offense as pleaded in the information for many reasons, among which is that it has prescribed. Second is that there is no multiple republication rule in the Philippines as far as cyber libel is concerned, because that applies only to print media. Third is that during the period from October 2012, when the Supreme Court was hearing the challenge to the Cybercrime Act of 2012, the Supreme Court had issued a temporary restraining order, which was made effective until the court decided with finality on the decision, which became final on April 2014. So one of the arguments there is that when, even assuming, and we do not concede this, but even assuming the theory of the prosecution that there is multiple republication, at the time that the item was republished, allegedly, in January of 2014, the Cybercrime Act was still under the TRO, and therefore there should have been no cyber libel arising from the January publication. The only time that the Cybercrime Act became fully effective was after the TRO was lifted in April 2014. So those are among the grounds. Of course, we also cited grounds against the charge that was filed against Rappler Incorporated, the corporate entity, saying that the information also does not charge the corporate entity with a crime. So we can furnish the media copies of the motion, but essentially those are the grounds that have been cited in the motion to quash. Okay? Very good. Anyway. Maria.
You know, I've called it legal acrobatics, right? Ted just told you why we feel this is legal acrobatics. I feel like it's ridiculous that Rappler and I have had to face at least 10 cases in the span of about a year, that I've had to post bail 6 times, and to be arrested and detained based on a cyber libel law that A, didn't exist, and B, even if you go by what the charge sheet says, may TRO nga eh, wala pang law. So anyway, maybe better, I'm tired of myself na eh. What would you like to know from us? We're fighting it in court. We're also at the same time realizing that the online battle has escalated in terms of the attacks on us, on me in particular, and on anyone who writes about the cases that we have or even express support online. If you've done that, you know that you get troll armies attacking you. The Washington Post yesterday was the subject of attacks. I think every one of your news groups have at some point been attacked. We can talk about the information ecosystem another time, but this works hand in hand to actually weaken our democracy. So please to the journalists, to the Filipino people, I appeal to you to demand facts, demand the truth, demand rule of law.